वॉइस ऑडिबल है मेरी? So today we will be moving. I have told you that organs of the state. No? So here we will be dealing with the legislature, executive, and judiciary. So we are done with these two parts, legislature and executive. Clear? So now we are moving towards judiciary. Clear? So we know that there is separation of power in the India between the legislature, executive, and judiciary. But as India is a parliamentary form of government, so there is no complete separation between the legislature and executive. Because in India, in case of India, see, in case of India, executive are part of the legislature, isn't it? Here, member of parliaments are ministers as well as legislature both. So there is no watertight separation in case of Indian parliamentary form of government. So you must remember this. Okay. But there is separation between the judiciary, legislature, and executive. And while teaching DPSP, Directive Principles of State Policy, I have told about Article 50. What is Article 50? Anyone? Any idea about Article 50? Hmm? No idea. See, Article 50 is a directive principle of state policy. You know that. And in Article 50, it is written that there should be separation between the judiciary and executive. Clear? Means state shall try to enforce the separation between the judiciary and executive. Clear? Now come to the next thing. See, judiciary in India. While teaching salient feature of the constitution, I have told that in India, judiciary is independent. Judiciary is independent as well as integrated. Clear? Judiciary is independent as well as integrated. What do we mean by both these two terms, independent and integrated? Anyone? Yes, by integrated we means in India there is hierarchy in the judiciary. Means at the apex level there will be Supreme Court, and then there will be High Court, and then there will be lower court or district court or session court. And any decision given by Supreme Court will be acceptable to the High Court and lower court also. Clear? So this is integrated judiciary. Is it a feature of federalism or not? Integrated judiciary is feature of federalism or not? Hmm? Why? Because here the verdict or decision of Supreme Court are binding on the High Court of the states as well as the lower court, means district court and session court. So it is feature of unitary form of government. Unitary form of government. Clear? Now come to the second part, independent judiciary. See, we know that India is a federal country, na? India is a federal country. Federal country means there will be two or more than two tier of government. For example, in case of India, there is a central government or union government and state government as well as local government also. So Indian federalism is a three-tier government after 1992 Act. So there is union government and state government. Clear? There is two government, union government and state government. So it might be possible that any dispute may arise between the union and state. It is possible, na? Dispute is possible. We cannot deny that. So who will decide? Who will be the judge in this case to decide about the dispute between union and state? Yes, it is Supreme Court. That's why Supreme Court in India has made independent. Clear? Why Supreme Court is independent? To decide independently between the any dispute between the union and state. Or it might be possible that there is a dispute between state versus state also. Isn't it? Huh? It is possible, na? A dispute may arise between the UP government as well as Bihar government or the Rajasthan government. So in that case, Supreme Court will have exclusive jurisdiction. Clear? Means if there is any dispute between the union and state or union and state in one side and other states in other side or dispute between state versus state. So in this case, Supreme Court will have exclusive jurisdiction. That's why Supreme Court has made independent in India. Is that clear? Why there is both independent and integrated feature of judiciary in India? Clear? Unlike USA, see, in USA there are two courts and both the courts are independent from each other. Clear? Supreme Court of USA for the federal constitution and the High Court for the state constitution. See, in case of USA and India, you can draw this table. USA has single constitution, na? Single constitution. Hmm? Sorry, India has single constitution. Sorry. India and here USA. India has single constitution for both center and state. And here in USA, they have dual constitution. Center and state. They have dual constitution. And since in India there is single constitution, that's why our judiciary is integrated. Integrated judiciary. Clear? Huh? But here in USA, they have constitution for the central government as well as constitution for the state government. That's why their judiciary is not integrated. Clear? Any doubt? Now come to the functions of the Supreme Court. Functions of the Supreme Court. See, while teaching fundamental rights, I have told about Article 32. What is Article 32? Right to constitutional remedies. Right to constitutional remedies. Clear? What does it mean? It means that in case of violation of fundamental rights, any aggrieved citizen can directly move to Supreme Court. That's why Dr. Bhimrao Ambedkar has said that Article 32 is the very soul of the Constitution, very heart of the Constitution. And it means that in India, Supreme Court is protector and guarantor of the fundamental rights of the citizen. So first function is the protector and guarantor of fundamental rights citizen. Protector and guarantor of fundamental rights of citizens in India. That is the first function of the Supreme Court. Clear? Supreme Court is the protector and guarantor of the fundamental rights of the citizens in India. Next function is, it is Supreme Appellate Court. Supreme Appellate Court of India. What do you mean by Supreme Appellate Court of India? Highest Court of Appeal. Supreme Court is the highest court of appeal. Highest Court of Appeal. This means that if any citizen is not satisfied with the verdict of the lower courts, that is district court or the session court, then he can move to the high court. And if he is still not satisfied with the verdict of the high court, then he can move to the Supreme Court. Is that clear? Why? Because there is integrated judiciary in India, na? So if you are not satisfied with the verdicts of the lower court, then you can move to the high court. And if you are still not satisfied with the verdict of high court, then you can move to the Supreme Court. So Supreme Court is the highest court of appeal. Clear? Now, another important function of the Supreme Court is the advisory function. Advisory function. See, this is given in Article 143. Article 143. Advisory function of Supreme Court. Clear? See, now understand it very clearly. President of India can seek advice from the Supreme Court on two matters. First one is any pre-constitutional matter. Pre-constitutional matter, clear? Or matter of urgent public importance. Urgent public importance. President can seek advice on any pre-constitutional matter or the treaty or the urgent public importance. Clear? Now, in this case, SC, Supreme Court, have to give advice. Have to give advice in pre-constitutional matter. Clear? It is compulsory on the Supreme Court to give the advice. But here in this case, may refuse to give advice. Is that clear? Huh? Supreme Court have to give the advice in matter of pre-constitutional matters or treaty. But in case of urgent public matter, it is not compulsory on the Supreme Court to give advice. Is that clear? And in both the cases means in pre-constitutional matters as well as in matter of urgent public importance, advice tendered by the Supreme Court is not binding on the President. Not binding on the President. Advice tendered by the Supreme Court is not binding on the President. Is that clear? कॉन्स्टिट्यूशन के पहले के मैटर्स, any doubt? Now we will be moving to the strength of Supreme Court. Strength of Supreme Court. See, this question has been asked by the UPSC in prelims. Ki who will decide about the strength of the Supreme Court? What do you mean by the strength of the Supreme Court? Means number of judges in the Supreme Court, including Chief Justice of India. So it is the Parliament. Remember, it is Parliament, not President. I have seen many aspirants have marks President in the exam or in mock test also. The strength of Supreme Court will be decided by the President. Sorry, decided by the Parliament, not President. Remember this. Clear? What would be the actual number of strength of the Parliament or of the Supreme Court will be decided by the Parliament. Clear? And as of now, maximum strength is 34, including Chief Justice of India. Clear? And it is maximum strength. What do we mean by the maximum strength? Means maximum allowed strength. It is not necessary that at a time Supreme Court must have 34 judges. It means at a time Supreme Court cannot have more than 34 judges. It doesn't mean that at a time Supreme Court must have 34 judges. Is that clear? It is the maximum allowed strength. Maximum allowed strength, that is 34, including Chief Justice of India. Clear? Now come to the next aspect, that is appointment of judges of Supreme Court. Appointment of judges of Supreme Court. See, for the appointment of judges of Supreme Court, there is a collegium system. There is a collegium system. What is the collegium system? There will be Chief Justice of India plus 4 senior most judges. Senior most judges of Supreme Court. This is the collegium. And this collegium will advise. Advise to whom? Advise to President. Clear? To appoint the judges of the Supreme Court. Is that clear? For the appointment of judges of Supreme Court, there is a collegium system. And as of now, collegium system comprises of Chief Justice of India plus 4 senior most judges of the Supreme Court. And they will give advice to the President to appoint the judges. So, who is the Appointee of judges. It is the president who appoint the judges. Clear? President appoint judges. Is that clear? And here one thing is also important. If president thinks that advice of Chief Justice of the High Court is also necessary, then he may ask for the advice of Chief Justice of High Court. Clear? Now come to the next aspect, that is qualification to become judge. Qualification to become judge in the Supreme Court. First of all, see, first is citizen of India. He must be a citizen of India. Clear? Second, judge of High Court for 5 years. Judge of High Court for 5 years. Or advocate for High Court, advocate of High Court for 10 years. Clear? Judge of High Court. He may serve in more than one High Court also. So combined duration or tenure of the High Court judges should be 5 years. It may be possible that he is judge of 4 years in UP and 1 year in MP. Then he will be eligible to become a judge of Supreme Court. Clear? So it is not necessary that he must be a judge in a single High Court. Clear? Another condition is he must be advocate of High Court for 10 years. And one more thing that is important here is, in the opinion of President, if any person is a distinguished jurist, distinguished jurist of the India, then President can appoint that person as judge also. Clear? What does it means? Distinguished jurist means these two conditions are not necessary. He must be judge of the Supreme Court, or he must be an advocate in the he must be judge of High Court for 5 years, or he must be advocate of High Court for 10 years. These two conditions are not necessary. Means president can appoint any person whom he think that he is a distinguished jurist. That person may be appointed as judge of Supreme Court by the president. But this is not in the case of High Court. Remember that. This concept of distinguished jurist is not there in the case of High Court. It is only for the Supreme Court. Complete. Now come to the next concept, that is tenure. See, there is no minimum age requirement. no minimum age requirement to become a judge of Supreme Court, but maximum age is 65 years. Means Supreme Court judges will have to retire if they attain the age of 65 years. Clear? So 65 years is the maximum age, and in case of High Court, it is 62 years. In case of High Court, it is 62 years. Clear? Now, there is a demand by the judges of High Court that their retirement age should be increased to 65 years. What do you think about that? So, judges of High Court are demanding that their retirement age should be increased to 65 years. They may ask you such question in the interview also. Think about it, okay, and let me know later. What are the pros and cons? Don't give the direct opinion without discussing the pros and cons. Clear? This is your homework. Do it and let me know whether the retirement age of judges of High Court should be increased to 65 or not. Clear? And they can also be removed. Supreme Court judges can also be removed. See, you cannot use the word impeachment here. Impeachment is used only for the removal of the president and for no any other constitutional post or any other post which is in India. So, Supreme Court judges can be removed from their office. And who will remove? President of India. See, generally those authority remove or suspend the remove the judges or any officer who are appointing authority. For example, in case of All India Services, Indian Administrative Services, President is the appointing authority. So, except President, no one can remove the IS officers. And here, who is the appointing authority? President. So, President will be the removing authority also. Clear? Now, see, there are two grounds. First one is proved misbehavior, and second one is incapacity. Proved misbehavior or and incapacity. These two grounds are mentioned for the removal of the judges of Supreme Court. Means Supreme Court judges will be removed if their misbehavior is proved. Clear? Or if they are incapable. And what was the ground for the impeachment of the president? It was only the violation of the constitution. And what is the violation of the constitution is not defined. So be very clear with this concept. For the removal of the Supreme Court judges, there are two grounds: proved misbehavior or incapacity. ठीक है? See, now who will prove the misbehavior? It is Parliament. Very good. Parliament will investigate the misbehavior of the judges, or whether judge is capable or incapable or not. So power of the investigation for the misbehavior of judges is under the parliament. Parliament will decide. Clear? And that must be passed in both the house of the parliament with two-third majority, passed by both house, that is Lok Sabha and Raj Sabha, with two-third majority, with two-third majority of the member present and voting. Clear? So that is the process of removal of the judges of Supreme Court. Clear? Now come to the ad hoc judges. What is the meaning of ad hoc? It is temporary, na? So ad hoc judges means temporary judges of the Supreme Court, and it is given in Article 127. You have to remember the articles also. Article 127. And what is the concept of ad hoc judges? See, what is quorum? Not for parliament only. It is for any meeting. In case of parliament, it is parliament. In case of judge, it is any session of the Supreme Court. Or you can also set meeting in your own organization. We need minimum number of such members to hold the meeting. So quorum means minimum number of person hold meeting, to hold any meeting. In case of Supreme Court, it is minimum number of judges required to hold any session of the court. Clear? So if that quorum is incomplete, that quorum is incomplete, then in this case, in case of incomplete quorum, clear, Chief Justice of India, on permission, prior permission of the president, या consent of president, prior consent of president, Chief Justice of India, with the prior consent of president, can appoint a judge of High Court, appoint a judge of High Court or any person who is qualified to become a judge of Supreme Court as ad hoc judge. Clear? So ad hoc judges are appointed by the Chief Justice of India. Remember this. Generally, we will take in the exam that president. So ad hoc judges are appointed by Chief Justice of India, but with the prior consent of the president. Remember this concept. Generally, I have seen that many aspirants fill in the MR that President is appointing the ad hoc judges, but it is Chief Justice of India who is appointing authority of ad hoc judges, but with the prior consent of the president. Now come to the another concept, that is acting judges. acting judges. It is given in Article 128. Article 128. See, again, Chief Justice of India, with prior consent of the President, may appoint a retired judge of Supreme Court or the retired judge of High Court. Chief Justice of India, with the prior consent of the President, may appoint a retired judge of Supreme Court or a retired judge of High Court who is qualified to become a judge of Supreme Court as acting judge. Retired judge of Supreme Court or retired judge of High Court who is qualified to become a judge of Supreme Court. Means any retired judge of Supreme Court can be appointed as acting judge in the Supreme Court by the Chief Justice of India with prior recommendation of the prior consent of the President. Clear? And any retired judge of High Court can also be appointed as acting judge. So any retired judge of High Court, if he is qualified to become a judge of Supreme Court, only in that case. Suppose a person is judge in High Court for 1 year. So can he be appointed as acting judge? No. Why? Because to become a judge of Supreme Court, any person must be a judge of High Court for the 5 years. So if any person who had been the judge of the High Court for 5 years and then he is retired, clear? Only that person who has the qualification to become the judge of Supreme Court can be appointed as the acting judge by the Chief Justice of India. Clear? Prior consent of President is necessary. Chief Justice of India. Now come to the next concept. It is given in Article 129. See, you will have to remember the articles also. Sometime in state PSC, they directly ask the articles. And in mains, if you will mention the articles in your answer, you will definitely fetch at least 1 or 0.5 marks extra. So try to remember the articles. It is not a one-day process, but I am sure if you will keep on learning or revising, you will be able to recall in the exam, whether it is pre or mains. So keep on revising these articles. Clear? Now come to the article 129. It says that Supreme Court is a court of record. Supreme Court is a court of record. Clear? High Court is also a court of record. So you can write down both. What do you mean by Supreme Court is court of record? See, it means any judgment or verdict given by the Supreme Court will be recorded for the future reference, will be maintained as a record and may be used for the future reference, and it will be applicable to all the other courts in the India. And second one is Supreme Court will have the power to punish for contempt of court. To punish for contempt of court. Court of record means also Supreme Court will have the power to punish for the contempt of court. Contempt of court means if anyone is disobeying or uh, refusing to accept the verdict or judgment of the Supreme Court, then he might be punished for the contempt of court. It means not accepting the order or verdict or judgment or decrees of the Supreme Court. So if a person is doing such things, then he will be punished for his contempt. Clear? Now come to the next concept, that is seat of the Supreme Court. Seat of Supreme Court. See, as of now, seat of Supreme Court is in Delhi. Seat of Supreme Court is Delhi. What do you mean by the seat of Supreme Court? Means the place where the meeting of Supreme Court will be held. So that is, as of now, it is Delhi. But its meeting can be held anywhere in India. Its meeting can be held anywhere in India. It is not necessary to hold the meeting of Supreme Court in Delhi. Clear? It can be held anywhere in India, but this decision will be taken by Supreme Chief Justice of India. Decision will be taken by Chief Justice of India. Again, with the consent of President. With the consent of the President. Clear? Means as of now, the permanent seat of Supreme Court is in Delhi. Clear? But the meeting of Supreme Court can be held anywhere in India. Any place. And who will decide that place? That place will be decided by the Chief Justice of India, but with the consent of the President. Clear? Now come to the jurisdiction of the Supreme Court. Jurisdiction of the Supreme Court. First come to the original jurisdiction. Original jurisdiction. See, original jurisdiction is discussed in Article 131. Clear? In Article 131. What do we mean by original jurisdiction? Means the cases which can be directly filed into the Supreme Court, and no other court can accept the cases on those matters. That is the original jurisdiction of the Supreme Court. Means only Supreme Court will be hearing the cases, hearing the matters on those cases. For example, if there is dispute between the government of India with the any state government, or if there is dispute between states, for example, dispute between state of Bihar and state of MP, can only be heard in the Supreme Court. That is the original jurisdiction of the Supreme Court. And if government of India is having dispute with the state government, for example, let's say Kerala government, then that case can be heard only in the Supreme Court. So this is the original jurisdiction of the Supreme Court. Clear? It means dispute between the center versus state as well as state versus state. Clear? Center versus state and state versus state. Or it may be possible that center plus state versus state, or more than two states. Clear? This is the original jurisdiction. Now come to the second, that is appellate jurisdiction. Appellate jurisdiction. See, appellate jurisdiction is discussed from Article 132 to 136. What is appellate jurisdiction? Means those cases in which a person can move from High Court to Supreme Court. These are not original jurisdiction. See, in India there is concept of integrated judiciary, na? So first a person will have to go to the lower court, that is district court or session court. Then if he is not satisfied with that decision, then he will move to the High Court. If still he is not satisfied with the verdict of the High Court, then he can move to the Supreme Court. Clear? And see, in case of India, appellate jurisdiction involves criminal matter, civil matter as well as constitutional matter. Write down, appellate jurisdiction of Supreme Court in India, it is for civil matters, for criminal matters and for constitutional matter. Clear? This is very important to know, because in case of USA, appellate jurisdiction is only for constitutional matter. Clear? But here in India, it is for civil matters, for criminal matters as well as for constitutional matters. Clear? Means if any person is not satisfied with the verdict of the High Court, whether it is civil matter or criminal matter or constitutional matter, then he can appeal to the Supreme Court. And see, one thing is very important here, that is Article 136. It talks about special leave petition, SLP. You might have heard this name multiple times. Special leave petition. See, according to Article 36, it is the discretionary power of Supreme Court. Discretionary power of Supreme Court means no person can force the Supreme Court, or it is not necessary that Supreme Court will accept this petition. It is the discretion of the Supreme Court whether to accept the SLP or not. Clear? And what is SLP? If Supreme Court thinks that any verdict or judgment passed by the High Court or any tribunal, any verdict, decree or judgment passed by the High Court or the tribunal, both for the High Court as well as tribunals, then Supreme Court may allow special leave petition against the verdict of High Court or the tribunal. But it is the discretion of the Supreme Court. It is not necessary on the Supreme Court to allow for the SLP. Clear? And SLP means any verdict or judgment or decree of the High Court or the tribunal Supreme Court may allow for the SLP, special leave petition, and it is the discretion of the Supreme Court. Clear? Another jurisdiction is advisory jurisdiction, which I have covered, so I am not going to repeat that again. Advisory jurisdiction is under which article? Tell me. Article 143, na? When I was talking about the function of the Supreme Court, I have told about the advisory power. So that is the same thing. So I am going to skip it. Okay? Now, come to very important topic that is also very important for mains. But before that, write a question which has been asked by the UPPSC. The question is, public interest every public interest is not a case for public interest litigation. Every public interest is not a case for public interest litigation. See, now come to the few concepts which I am going to explain. First one is the PIL. PIL means public interest litigation. Public interest litigation. What do you mean by the public interest litigation? See, public interest litigation means it is not necessary that only aggrieved person can file the case in the court. Clear? See, Indian judiciary is very cumbersome and very costly. So, marginalized section have always faced difficulty to access the justice from the court. And this has been seen very clearly during the emergency period. The marginalized section and backward section of the citizen are not getting access to the justice in any court because of the highly cumbersome and costly procedure of the Supreme Court. and it is written in our preamble that there will be justice, social, economic, and political. So, isn't it a violation of the preamble or the philosophy of the Indian democracy? है ना? In the preamble, we are saying that we will give justice, social, economic, and political to all our citizens. And here, Supreme Court or High Court, the judicial process is very cumbersome and very costly. So, marginalized section or weaker section or vulnerable section are not getting access to the justice, not getting access to any court. And this has been seen in the emergency very clearly. So, in 1980s, you have to remember the name of two judges, Justice P.N. Bhagwati and Justice Krishna Iyer. Write down the name of these two judges. This has been asked by the various state PSC. Justice P.N. Bhagwati and Justice Krishna Iyer. See, these two judges recognize the possibility of giving access of the justice to the marginalized section also. And they gave the concept of public interest litigation. And the concept of public interest litigation is that it is not necessary for aggrieved person to file a case in the court if it is related to the public interest. So, if any matter, any issue is related with the public interest, so any other person, it is not necessary that only aggrieved person, any person, any organization, any civil society group, any pressure group, any NGO can file a case in the court on the behalf of those people, on the behalf of public interest. Earlier, before 1980s, only aggrieved person can move to the court. But access to justice is very cumbersome, very costly in India. So Supreme Court has allowed for the public interest litigation and says that any person, any organization, any NGO, any civil society group can approach to the Supreme Court for the public interest if any matter is for the public interest. For example, if matter is related to the climate change, matter is related to the slum rehabilitation, clear? Matter is related to the victims of communal violence, communal rights, matter is related to the environment protection, means any matter which is linked with the public interest, clear? And this concept of public administration gave birth to the concept of judicial activism. Write down judicial activism. Clear? What is judicial activism? Judicial activism means proactive role played by the judiciary. Proactive role played by judiciary to ensure the social justice, to ensure the equity, to ensure the social empowerment. Clear? So judicial activism means proactive role played by the judiciary. When other organs of the state are not playing their role efficiently and effectively, then judiciary will be proactive. Clear? For example, if there is frequent disruption in the parliament and parliament is not focusing, a legislature or executive are not focusing on the urgent matter of public importance, then Supreme Court may give the guidelines to form the law. For example, on the matter of triple talaq. Supreme Court has ordered the Parliament to formulate law on the triple talaq. Vishakha guideline. Supreme Court has ordered the Parliament to make law, to enact law on the sexual harassment at workplace. So you can mention the example of these two cases. Cases of triple talaq and case of Vishakha guideline. So is there any problem with the judicial activism? Is it good or bad? See, judicial activism is good. Good when there is judicial restraint. Judicial restraint. But it is bad. Bad when it is judicial overreach. Judicial overreach or judicial adventurism. Judicial overreach or judicial adventurism. Clear? Judicial restraint means judiciary is proactive, but it is not encroaching upon the jurisdiction of executive and legislature. Judicial restraint means judiciary is proactive. Judiciary is uh, proactive and judiciary is performing judicial activism, but it is not encroaching upon the jurisdiction of the legislature or executive. So this is good and this is necessary, especially when the other organs of the state are not functioning properly, efficiently and effectively. But in the zeal of judicial activism, sometimes judiciary encroaches upon the jurisdiction of the legislature and executive. In the zeal of judicial activism, sometimes judiciary encroaches upon the jurisdiction of legislature and executive. Then this is called as judicial adventurism or judicial overreach. Clear? You got the difference between these two things now? These terms are very important for your mains. So judicial activism is good when there is judicial restraint. Means judiciary is not encroaching upon the jurisdiction of the legislature and executive. But when in the zeal of judicial activism, judiciary is encroaching upon the jurisdiction of legislature and executive, then it is judicial overreach or judicial adventurism. Clear? For example, here you can give the examples also. Example of judicial overreach. Few years ago, Allahabad High Court had passed a verdict that all the children of IAS officers or PCS officers will have to study in the government school. Allahabad High Court passed this judgment. So isn't it a overreach of judiciary? Is judiciary authorized to take such decisions? Also, they have passed the judgment few years back that liquor shop cannot be opened within the 500-meter of highway. So it is the work of judiciary to see where the liquor shop would be open or not. It will be seen by the executive and legislature now. They will decide. Also, they have done unnecessary censorship in Jolly LLB movie. It is not the role of judiciary na, to do the censorship and unnecessary censorship in the movies. So you can cite these examples to fetch extra marks. Otherwise, you won't get extra marks. If you'll just write the concept, you will have to give the case studies. You will have to give the examples to substantiate your point, to fetch extra marks. Clear? Any doubt in this concept? PIL, judicial activism, judicial restraint, judicial overreach, judicial adventurism? No, that is not necessary. Clear? And I have already explained the concept of judicial review. So I am not going to explain that again. I hope that is clear. Huh? Any doubt?